Hello, everybody. Welcome to the latest edition of CNF Talks. Today I have with me Stefan Geering, who's a Global Privacy Officer and Trustworthy AI Lead at Anthology. And Stefan's going to be speaking at our AI Regulation Summit, which is being held in London on the 27th of January next year. Stefan, welcome.
Thanks for having me.
It's very good to have you with us. First of all, Stefan, can you just tell us a little bit about your role at Anthology? Global Privacy Officer, I can understand. Trustworthy AI Lead. But what's the sort of definition around that in terms of the lens through which you look at these issues?
Yeah, and I'm probably kind of in a similar position to many of kind of my privacy colleagues that started kind of in a role as kind of a be that data protection officer, global privacy officer, and then as kind of ChatGPT kind of entered the focus of all the attention, and companies understood that they need to implement responsible AI or what we call trustworthy AI programs, that some of the privacy teams kind of inherited or were volunteered to kind of take on that part of the work as well. And while obviously there's privacy as aspect of the whole aspect of responsible AI, there's much broader range of risks that need to be addressed as part of that. But in kind of my role, I'm owning kind of the global compliance with privacy, but then also making sure that we as a company are kind of responsible in how we use AI kind of across the globe, not just from a privacy perspective, but much more broad perspective.
Fantastic. That's very helpful to understand. And obviously, AI regulation, it goes from the pro-innovation approach to the safety-first approach and anywhere in between on that sliding scale. Uh, when you look at the EU AI Acts, what are the risks you see there from your perspective then in terms of privacy, in terms of trustworthiness?
Yeah, so the EUA Act is kind of interesting because it's arguably, I mean, the Chinese may disagree a little bit, but kind of arguably the first kind of comprehensive approach to try to regulate AI.
Yeah.
And I mean, the interesting piece about it, and it's kind of a good reminder for people like myself coming from the privacy space, privacy obviously a really important component, but the EUA Act is actually based on product safety legislation. So it's kind of that's why you have the conformity assessments, the quality management system, and all of that. And I
Mm.
think that's kind of where people like myself had to kind of quickly get up to speed with kind of the product safety principles and learn kind of about all these sort of risks. And I mean, we can think about in terms of risk. I mean, some of our risks that we have known for quite a while in terms of AI, kind of typical risk like fairness and bias. Kind of, you know that obviously if you train a system on training data that has some bias in the training data set, that bias may trickle down into the system. And we all know the examples, kind of if you ask kind of ChatGPT or some kind of other tool to kind of draw you a picture of a doctor and a nurse, you can kind of guess who is going to be the man and who is going to be the woman in that picture. And then we, of course, have things like accuracy that's new with generative AI, where we need to make sure that we focus on the hallucinations, the issues about inaccurate. But there's kind of also security aspects, kind of where we kind of with prompt injections or aspects, people can try to either circumvent certain guardrails that kind of the LLM providers have implemented and kind of get access to training data or kind of get the LLM to kind of provide, kind of produce dangerous outputs. And then, of course, the more broader risk of that there's not enough kind of governance and transparency around this, and that humans are no longer in control of kind of some of the decisions making. So that's kind of why the EU Act has this kind of comprehensive approach. And I mean, it can go into a lot of details, but kind of with these four tiers of kind of prohibited,
Yeah.
unacceptable risk to kind of the high risk, which includes some HR and education use cases, and then kind of the more limited risk, where it's mainly around transparency and kind of the almost zero risk. So it's kind of a risk-based approach that touches on all of these risks and has kind of, depending on how risky a certain use case is, has different requirements and
Mm.
obligations for providers.
So, as you say, that's a very comprehensive model that we have in the EU. In the US, perhaps towards the other end of that spectrum that we were discussing, there's much more of a pro-innovation approach, and I guess you would see that then as coming with a fair degree of risk.
Yeah, it's interesting to compare kind of the US and European approach. I mean, kind of similar to privacy, the US is it's kind of more like a patchwork approach at the moment. I
Yeah.
mean, and this is kind of almost necessarily because, as many will know, kind of it's very hard to pass any legislation in Congress on the federal level. So a lot has been done kind of on kind of it at the help of executive orders that can be issued by
Mm,
president. So we have this really comprehensive AI executive order that was issued, I think, a bit more than a year ago, that
mm,
really requires a lot of US federal agencies to come up with programs and define requirements for the various areas that they're responsible for. And then we have kind of on the state level, we have states kind of that have been starting to implement laws.
yeah.
And these are kind of typically a style, kind of very sector and risk specific. So we have,
Mm,
for example, New York, a specific law regarding use of AI in hiring. Then
mm,
Colorado Act has kind of taken a, well, not exactly the same, but kind of similar risk approach to you, where it's kind of focused on high risk system as well.
yeah.
So there's lots of different laws in on the kind of the state level. So it's kind of a federal layer, a state level, sometimes even city level, that kind of have different
Mm,
implications. It's much more patchwork. And there's,
yeah.
and you, we of course have the very comprehensive kind of uniform UA.
And in the UK, I guess we're seeing the emergence of a new model, moving on from the thinking of the previous government. And I guess that's something more of a halfway house. And do you think that that's a better balance between the safety and the risk aspect?
Yeah, I think it's a bit early to say, because I mean we still need to see all the details here. But I think the interesting piece is going to be, I mean, if you're a kind of a service provider company that kind of just provide service within the UK, then you can kind of fully focus on that approach. But obviously, because the EU AI Act is a product safety
Yeah,
legislation, if you as a UK company want to export anything or provide services to your citizens, you kind of invariably have to implement the EU AI Act to make sure you still have
yeah,
access to
yeah,
the EU single market. So I think
yeah.
I can imagine that a lot of companies in the UK who at least do some kind of export or provide services into the EU market or want to do in the future will have to
Mm,
kind of closely follow the EU Act as an approach.
mm. Yeah, yeah. No, I'm sure that that's absolutely right. I mean, you talk about the sort of fragmentation in the US, but I guess, across the world, there's a patchwork of systems. And what does that mean then, from a regulatory point of view? Do providers of systems have to adhere to the highest level of regulation, do you think, in order to export globally? Is that what happens, or do they simply comply at a national level? It's sort of fairly inefficient if you're a global AI company.
Yeah, I mean this is a challenge for all kind of companies, and kind of from my experience in the privacy space, kind of the EU GDPR has almost become kind of the global standard, and we kind of as a
Mm,
company use it as a baseline. Lots of other companies do. So that has become a bit easier. I think on the EU, on the AI regulation piece, we kind of in a much earlier phase where it's not really clear yet. It's going to be the
yeah.
EU AI Act that is the global standard. Will there be another approach that will dominate? I mean, Singapore has quite an interesting approach to the regulation of AI, kind of it just kind of the halfway house between innovation and also kind of sufficient regulation. So a bit early to tell. I mean, I think the EU Act will definitely be very influential
Yeah.
because it's very comprehensive, but at the same time, we've also seen that it's not perfect. I mean, one example, for example, that only last minute, the whole aspect of the general purpose AI system, so LLMs have been introduced last minute because
Mm,
the EUA Act actually started before the big kind of release of ChatGPT and wasn't even considered. So there's kind of the danger that the EU Act may be the first, but because of its kind of early on, it may miss some of the critical technical developments that you may see
yeah.
in 1 2 years because things moving just so quickly.
Yeah. And turning to one specific risk, with your privacy and trustworthiness hat on, where vendor risk, third-party risk, what's best practice there, do you think? How do institutions and companies manage that risk? They're outsourcing this to vendors. How do they ensure that they're not simply unaware of the risk? How do they manage them properly?
Yeah, that's a good question. I mean, and some of it is not really new because a lot of companies use cloud-based services already, so they're already outsourcing quite a lot of kind of in terms of privacy and security controls to
Yeah.
vendors. So most companies will have kind of through the procurement process or a separate kind of third party or vendor risk management program will have kind of due diligence in place, making sure that they're comfortable that the vendor meets their own standards, by kind of sending questionnaires, by doing audits, by reviewing their SOC 2 reports, ISO certification, whatever it is. And I think on the AI piece, we can just leverage that and build on it. I mean, there's obviously one of the significant important aspects that many companies have is kind of the concern that your data ends up in the training data of some kind of vendor, and kind of be like many other companies use kind of the generative AI API services that companies like Microsoft or AWS provide, where you basically take a cloud-based LLM off the shelf and kind of include this in your products. But basically, it's driven by Microsoft and AWS with the help of OpenAI and Anthropic. And there, yeah, you really need to make sure that you're comfortable kind of how Microsoft and AWS and similar companies handle your data. And there are some commitments on not using that data for kind of training their own models, which is generally the case for enterprise licenses, but also otherwise how they kind of responsibly use kind of the AI systems.
Great. Well, I think we've probably run out of time there. So for our viewers, we very much hope you'll be able to join us at the AI Regulation Summit on the 27th of January in London, where you'll hear more from Stefan and our other expert speakers. So if you want to find more information on that, do have a look at our website, www.citionfinancial.com. Stefan, thank you very much for sharing those thoughts with us today.
It's been a pleasure. Thanks for having me.